Good morning, everyone. My name is Dinesh Agarwal, and I welcome you this morning to our webinar on JobKeeper 2.0 with the extension to the March 2021 and the changes under the new legislation. I can see a lot of attendees joining, so we will just allow another minute or so for the other attendees to join as well, and we will kick start. The structure of this webinar this morning we'll just have a brief introductions and introduce the speaker and get straight into the presentation, and we'll have a question and answer towards the end. If you've got questions throughout the presentation, please pop them into the chat box, and we will try to address as many questions we can. We'll have enough time towards the end of the presentation. So we've still got a few more attendees coming in. We had a lot of apprehensions a couple of months ago before JobKeeper 2.0 was announced that whether the government is going to either suspend or scale down, considering how Australia recovered very fast and managed to come out of the COVID situation to some extent. But considering what transpired in Victoria and gradually, emerging in some of the other states, it quickly changed the view and the anxiety that brought back. And I presume the government acted quite fast in terms of introducing the JobKeeper number 2 and least any suspension of JobKeeper 1. They have extended JobKeeper under 2.0 with very minimum changes. Of course, the eligibility criteria has slightly changed and the testing periods have slightly changed, but it has been extended for 6 months up to March 2021. So we got enough attendees. We still got a few more joining in who are running late, so we'll proceed with the presentation, and they will join us as they come along the way. So just a quick disclaimer, the information contained in this presentation is general in nature and does not take into account your personal situation, so you should consider whether the information is appropriate to your needs, and where appropriate, please seek professional advice. Just a little bit about Fortuna Advisory Group. We are a multi-service accounting practice based here in Balcatta, and our regional office in Carnarvon. We offer holistic solutions in tax and business advisory, financial planning, legal services, and mortgage broking. We are an award-winning professional services group with some of the key awards being the best multi-service practice of the year at the National Australian Accounting Awards of 2019, and very recently the best boutique advisory practice of the year 2020 at the National Australian Accounting Awards, and also the Telstra state finalist in 2019 in medium and making waves categories. So we have a lot of credentials and knowledge and expertise and resources behind our team and as a group, and offering very comprehensive solutions to our clients. A little bit about myself. I'm being the managing director. I've have more than 20 years of experience in accounting, finance, and business management in the top corporate positions, both in Australia and overseas, and provide not only manage in major international clients, but help a lot of SMEs and family-based businesses to set up and grow and scale in Australia. One of the most prestigious awards, personally being recognized in the top 3 SME tax advisors in 2015 by the Tax Institute. I would like to introduce our main speaker for today, Stephen Gethin, who's Director of Fortuna Legal. Stephen specializes in tax, business, property, and self-managed super fund law. Over 20 years of experience in major law firm and international ASX-listed companies. Steve excels in structuring and documenting complex transactions, particularly where challenging tax issues are involved, and his in-house experience has given him a deep understanding of the issues faced by the business and ability to explain complex legal issues in clear language. So with this, I hand it over to Steve to start the presentation.
Thank you very much, Dinesh, and welcome to our clients and visitors. Yes, it was touch and go there whether this JobKeeper was still going to exist even now. There was some suggestion it was going to disappear in July, as everyone was doing a very good job of recovering. And you know, congratulations to those of us who have managed to get back to where we were or close to where we were beforehand. Yes, so we probably do owe this to what's happened in Victoria. Had it not been for this, I don't think we'd be seeing this package. So this is known as JobKeeper 2.0. There were a number of changes announced in rapid succession about a month ago. Firstly, known as JobKeeper 2.0 and then 2.1, but we're just lumping them all together and treating them as 2.0. So basically, as you all know, JobKeeper was due to end almost at the end of September. It's now been extended for another 6 months until the 28th of March 2021. The payments have, however, been reduced. And there's, I guess, the main concepts about the extension are there's 2 periods and there's 2 tiers. So you've got a matrix of 4 different alternatives which depend on how much your employee gets. Each of your eligible employees receive. So tier 1 employees and business participants, so remembering this is not just employees, this is sole traders, this is one working director per business or one trust beneficiary who works in the business per business, who work at least 20 hours per week on average in the December quarter, that's period 1, they can receive $1,200 per fortnight. In the March 2021 quarter, that's period 2, they can receive $1,000 per fortnight. And the tier 2 employees, and this is to address what was probably a fair criticism of the scheme, that someone could be working 3 or 4 hours a week and they then qualify for $1,500 a fortnight. So the government hasn't totally resolved that problem, but they've gone a long way to resolving that problem by stating now in these 2 quarters, December and March, that if you work less than 20 hours a week, you qualify for a lower rate, which is a little over half. So in the first period, the December 2020 quarter, those less than 20 hour per week employees will be getting $750 per fortnight. And in the March quarter next year, they will be receiving only $600 per fortnight. Now, obviously, some people's hours do vary. So it's actually taken, your hours are worked out as to what were your average hours over a test period. And the test period is either, it's a little bit unclearly explained on the ATO website. And about that, as with the initial JobKeeper, what we're dealing with here is we're not dealing with fully detailed acts of parliament or regulations yet. We're still dealing with mainly press releases and information on the ATO website. The government did introduce a law into Parliament a couple of days ago, but the law says virtually nothing about the payments. It's just a law that allows the minister to make another detailed set of regulations as per the first set. So we're not sure when those are being released. But what the ATO says about this testing your hours of work is that averaging is taken for the 4 weeks of pay periods before either 1 March or 1 July. So I guess what they're roughly saying is it's going to be how many hours you worked in February or in June. And it's not clear whether you can just pick either of those or whether, the March period applies to the December quarter and the July period applies to the March quarter next year. We'll find out. Again, it's possible that someone may have had an unusually short number of hours in one of those test periods, and there is a test to deal with that, just as we've had alternative turnover tests for businesses that might have had a unusually high turnover at a particular, unusually low turnover at a particular comparison period, or they weren't even in business at a particular period. There is a provision for people who, for some reason, because they were ill or they were on leave in one of those test periods, were working an unusually low number of hours. If they can establish that they would have otherwise been working at least 20 hours in either of those applicable test periods, then it's expected that they can qualify as being a a tier 1 employee or a tier 1 business participant, someone who works more than 20 hours per week on average. Another weakness of the scheme is that, it was difficult to take on, you couldn't take on new employees. Your employees had to be employed before 1 March. That hasn't been totally fixed, but it's been improved in that now the cutoff date is 1 July. So if you started someone after 1 March but before 1 July, they can now qualify. They may have come over from another employer, or they may be new to the workforce, or they may even be someone who was didn't previously qualify but has just started to qualify before 1 July. Now, previously in JobKeeper 1.0, it operated for 6 months, and if you satisfied the decline in turnover test for even a single month in that 6 months, your business was then eligible for JobKeeper for the whole 6 months. The government has tightened that up a little bit. Now they're going to retest you each quarter. So in order to qualify for this new JobKeeper to be paid this in the December quarter, you need to prove that your turnover for the September 2020 quarter was the required percentage below the corresponding quarter in 2019. And that, as we all know, that percentage for most businesses, unless you happen to be earning $1 billion, which I don't imagine too many in the room are doing, then it's 30%. So, and as previously, the test is based on GST turnover, which may differ slightly to your turnover measured for other purposes. And previously in JobKeeper 1.0, and this still obviously applies up until the end of September, you could qualify by using your projected turnover. I think the government has found that it might have been a little bit too easy. Some people were, sort of projecting their turnover a little bit pessimistically to qualify. So now the government is only going to look at your actual turnover, which is probably easier for business to comply with, because you just look at your accounting package, gives you a report, as opposed to trying to estimate, which kind of stresses people, because you think, well, what if I get it wrong? Am I going to be misleading the ATO? At least they've taken that lack of certainty away, albeit made it slightly harder potentially to qualify. So yes. So first extension period, as mentioned, we'll come to the second extension period. So to qualify in the second extension period, that's for the March 2021 quarter, you need to show that your turnover for the December 2020 quarter was at least 30% less than your turnover in the December 2019 quarter. Now, as you know, in JobKeeper 1.0, you don't have to you can qualify on a quarterly basis if you wish, but you also have the ability to pick a single month within that first 6 month period, because you may have a quarter that's not really down, but you may have just had one bad month. And we know some businesses in that category, they took an initial quite a big haircut, but then actually it turned out that their business was one which actually had something that was particularly valuable at the time of Corona, but it just took people a while to realise that. Like some WA travel related businesses in particular, they may have had an initial haircut when there was a intra-state lockdown, but soon enough people discovered, well, you can't go to Bali anymore, so we now have to go to Monkey Mia or Broome. So those people are now doing very well, but they could still possibly have qualified for JobKeeper because their first month was bad. Well, now the government said, well, in this 2.0 periods, you need to prove that your turnover is down for a whole quarter, not just for a single month within any given quarter. Also note that you don't need to have qualified for JobKeeper 1.0. Some businesses may have been doing okay during the first JobKeeper 1.0 period, and they may have found that their turnover has now declined by 30%, and they can now come into the system. That's probably not going to be very common, but there could be some businesses in that category. I mean, what we're actually seeing in WA is quite a lot of businesses may not be able to qualify for JobKeeper 2.0 simply because they've either recovered completely, or more commonly, they've recovered to the point where they're not 30% below their previous turnover, but obviously still a useful scheme for quite a few businesses that are still dealing with some fallout from this pandemic. Next slide. Yep, so you need to, if you've taken on a new employee before who started after 1 March but before 1 July, and you wish to qualify for that employee, well, firstly, if you do have any employees in that category, it's still one in, all in, so you do need to give those employees the opportunity to participate, and it's not actually clear that there'd be any good reason why anyone wouldn't want to do that. So as with the pre-March 1 employees, if you've got a pre-1 July employee who started after 1 March but before 1 July, you need to give them a form which you can download from the ATO website. They need to choose whether they want to get it through you. I mean, if they may have another source of employment where they're getting it instead, but if they're going to choose your business, they need to give it back to you. Now, the ATO did say that that needs to be back by the 24th of August. However, there still may be some flexibility around that because I think it's taken a bit of time for this information to filter through. So if you haven't done that, you've got a pre-1 July employee that you want to claim for, go and get that form off the ATO website, fill it in, give it to your employee, get them to sign it and give it back to you immediately. You don't give it to the ATO, you have to keep the form, but it's there in case you get audited. And obviously you wouldn't want to go backdating it because there's ways that could be, well, A, it's illegal, and B, it's, there's ways that could be determined that had been done. But just do it as quickly as possible if you haven't already done so. And I think there's going to be a bit more leeway about that potentially. There's a bit of an extension for only for employees who've started before 1 July. There's an extension until the 31st of August to pay them their wages for the fortnights ending the 3rd and 17th of August. There's also a possibility that someone who was working for you, but especially if you're in the sort of food industry, food service industry, we may have younger workers. You may have had employees who were 16 or 17. They're working for you before 1 March, but they couldn't qualify. If any of them have turned 18 since 1 March and before 1 July, you're now able to claim for them. There are some special rules for childcare workers, which I actually haven't gone into here. But if we have anyone in the childcare sector who would like some more information about that, do please let us know, and we can fill you in on that. And there's some transitional rules for some businesses that might be partly involved in childcare and partly in something else. Next slide, Dinesh. Yes, so many things have stayed the same. As mentioned, the turnover tests are still the same. If you're in a charity, it's still 15% decline required, 30% for almost everyone else. Now, short-term casuals and minors are still excluded. So just it's worth recapping what is a short-term casual. There's quite a bit of confusion around that. A short-term casual is a casual unless they've been employed for more than 12 months on a regular and systematic basis. But people might assume, well, regular and systematic, that means my casuals won't qualify unless, for example, they always come in on Tuesday and Wednesday at the same hours. It doesn't actually need to be anywhere near as regular or systematic as that. This concept also arises under Fair Work, and there have actually been quite a few cases under Fair Work about when a casual is regular and systematic because they get extra rights. And Fair Work has been fairly lenient in terms of finding that people are regular and systematic when you might have actually thought they were irregular and unsystematic. So always, if you're in doubt about whether a casual qualifies, if they've been there for at least a year, even if they have fairly random varying hours, they may actually still meet that test, because it's expected that if a court or ATO was scrutinising whether someone was a systematic or regularly employed casual, they would apply the same approach that's been applied for many years under Fair Work. Also, you must be 18 years old before the 1st of July, unless for the case of 16 or 17-year-olds who are independent. That's got a special definition under some social security legislation, but it effectively means that they're not being supported by their parents, and they also need to not be in full-time education. Next slide. Some other things which remain the same. Employees with a multiple employer you have an employee who is employed by you and another independent employer, they can choose which employer to be nominated by for JobKeeper, but as we know, they can only claim it through one employer. However, a long-term casual who also has a permanent employment somewhere else must claim through their permanent employer. So there's a bit of opportunity now for what's unfortunate, we were hoping would be fixed, but hasn't been fixed. You may have had someone who was an employee that you qualified for JobKeeper for because they were employed with you before 1 March. They then left, or you had to possibly even dismiss them. You were claiming JobKeeper for that person. They left and you dismissed them. And then you've taken someone else on. Well, you couldn't claim JobKeeper for that new person. The 1 July rule has sort of fixed that, at least if you did take someone on before 1 July to replace a dismissed employee that you were getting JobKeeper for. Well, now you're getting JobKeeper for that new employee. But of course, if you've had someone there from however long and you dismiss them after 1 July and then you replace them, unfortunately, there's no JobKeeper for that new employee, and that's something which is probably going to stay. If it was going to be fixed, it would have been fixed now, and unfortunately, that hasn't happened. So, so there is potential to there switch employees or switch employers or switch employees and still get JobKeeper in the new situation in limited cases. Businesses which engage with independent contractors, you do need to be careful about if you have a few independent contractors, by which I mean a person who really does pretty much the same thing as an employee, but they're just called a contractor. This is often a thing. People often try to classify someone who's really an employee as a contractor to try and remove obligations for to pay certain things that are payable to employees. There's a reverse incentive here for independent contractors to try to make themselves look like employees. Although if they're an independent contractor, they may be able to claim themselves as a business participant on the basis that they are a sole trader. But it's just a matter of getting it right who they claim through. And look, potentially if that person was going to get JobKeeper themselves outside your business as a sole trader, or whether they the line was blurred and they were considered perhaps wrongly to be an employee of your business, as long as they're only getting it under one hat, we don't imagine there's going to be a major issue raised there by ATO, but it's probably just something to focus on if you're not sure. If you've got an employee though, and you make them contract with you through a company or a trust, they are definitely a contractor and they need to claim through their own company, not through you. Next slide. So the wage condition, again, worth focusing on. I mean, there's a lot of unfortunate consequences of JobKeeper around the need to pay employees in advance. We had hoped that might be fixed, but unfortunately, no, still that need. Most payments that you make to an employee, so as you know, the wage condition is whatever the amount is. I mean, the amount now until the 28th of September is that $1,500 a fortnight. Obviously, that amount comes down for the December, then reduces further in the March 2021 quarter. But the question is, what counts towards that amount? So basically, most amounts that you pay to that employee connected with their employment, but not necessarily all amounts. So salary, wages, commission, bonus, and allowances are all included. They will go towards paying that that $1,500 at the moment, or that $1,200 as it will be after September. Also amounts that you withhold, so things that you, your PAYG amount that you deduct, that's also counted as if it had been paid to them. Contributions that you make to their superannuation fund, and if they're on a salary sacrifice, then the value of things that you've purchased, the money that you've taken out of their salary and then applied towards paying their car lease or whatever, is also included. The main things that are excluded, and we get this question quite a bit to see whether we can get, people want to know whether they can get JobKeeper to help fund an employee's exit costs, employee termination payments, including unused leave entitlement payouts, are not. So actually, what can make sense if you can arrange it with the employee, you've got an employee who's got a fair amount of leave, instead of letting them go on a period of notice which is shorter than their unused leave, and then you have to pay them a lump sum for their leave, you just let them stay employed, but then they take that leave, and then it's eligible for JobKeeper. Again, the system is set up on the assumption that everyone's paid fortnightly, but because they're not, you pay your employees monthly, then as you know, the ATO will take reasonable apportionments of a monthly pay to the fortnights that fall within that month to see whether you paid the employees the right amount in each of the fortnights. Yeah, next slide, please, Dinesh. So as we know, people in small business in the ownership capacity are not eligible as employees, but one per business can qualify as a partner in a partnership, which is a bit unfortunate because where you've got a partnership of two or more independent people, you would have thought that they're each equally, at least morally, entitled to JobKeeper, but legally it's only one partner per partnership. And there's shareholder, director, beneficiary of trust and partner in a partnership. Only one out of that whole group can qualify per business. So, you know, if you've got a trustee, your business is run by a trust, which is quite common. You might have two directors in the trustee company, and you might even have, you know, domestic partners who are just beneficiaries of the trust, but they come in to help out. You know, so there's two families running a business in that way. Well, only one of the, say, four ownership people with an ownership interest can claim, which is somewhat unfair. But I guess we're getting free money. We can't be too critical of the conditions on which it is handed out. Yeah, so again, you some eligibility conditions there, which I won't go through. They don't change. So next slide, please, Dinesh. Now, JobKeeper ends. Obviously, that date has been put off. If you can't afford to keep your employee once the subsidy ends, then you do have options to make them redundant. There's a little bit of a technical process to go through to make someone redundant. You need to consult with them, genuinely listen to, have they got any alternative, genuinely consider, are there any alternatives to making this person redundant? Have they got skills that could be used in another capacity in the business, even if it's on reduced hours or different duties? Have lots of, you know, meetings with them where you tell them in advance what you're thinking about, hear their views, and then make, and obviously enough in many small businesses, there aren't really a lot of good alternatives, but you still need to go through the process. I mean, there is an exemption for businesses under 15 employees as well, although note that that's quite a tricky test to meet, because if you've got a casual who works 1 hour per week, they're counted as a single employee. So some businesses who don't really seem to have many employees actually are not a small business under that Fair Work test for redundancy. And yeah, there's been quite a lot of changes to Fair Work as well. As people are aware, under JobKeeper 1, Fair Work was amended to give employees, if employers don't normally have, well, it's not easy to stand people down when there's a temporary reduction in work. Fair Work is traditionally, a job is all or nothing. Either you've got a job and the person turns up each day and gets paid, or if the employer thinks that there's not enough work for them to do, well, their main option is to make them redundant. There was some limited provision in Fair Work for standing people down when there wasn't enough work, but JobKeeper 1 made that a lot clearer. There's a lot better to employers to stand down an employee because of Corona, where there's not enough work for them to do. That has been extended, but weakened. There's quite a complex set of new provisions around that. There's a need to satisfy a 10% reduction in turnover test to be eligible for those additional rights that employers have to give employees directions to stand down. So it's beyond the scope of this seminar to go into that, but if anyone has any detailed queries about the Fair Work side of JobKeeper, please feel free to drop us a line and we'll be happy to elaborate on that for you. Next slide. And to just quickly skim through some of the technical things here. Do you withhold PAYG from JobKeeper payment? Yes, it's just ordinary salary. Do you withhold PAYG from a payment to a business participant? If they're also an employee, like some directors are also employees, if the director works in the business, they're an employee, and if they're taking out money as directors' fees. But if they're taking money out as dividends or drawings or loan balances, then no, you don't take PAYG out of that. And obviously sole traders don't take out PAYG. Next slide. JobKeeper payments are included in your assessable income, but they're almost certainly going to be 100% set off by a deduction when you pay that same amount to your employee. So they're not really going to cause you a tax problem. GST does not apply to JobKeeper payments. If you receive JobKeeper for an employee, you must pay it to them, but if you receive JobKeeper for a business participant, you don't actually need to pay it to the person, so they don't have to meet that wage test that is applied to employees. And in WA, JobKeeper payments are excluded from wages for payroll tax. Next slide. So the superannuation tests, we haven't really seen whether, I haven't found out whether they are going to be changed. I mean, obviously the amounts here, the $1,500 relate to JobKeeper 1, so you'll substitute that $1,500 for the new $1,200 or $1,000 amount, determining to what extent you have to pay super. So if someone was previously being paid more than the JobKeeper amount and you reduce their wage down to the JobKeeper amount, you still need to pay the superannuation on the full amount that you're paying them. But you can reduce their payment to $1,500 or $1,200 or whatever the amount is at the particular period, inclusive of super. You don't need to pay them super on top of the JobKeeper amount that you're paying them. Next slide. And that brings us to the end of the presentation. So I'll hand back to Dinesh, and Dinesh will run a brief question and answer session.
Thank you, Steve. Great insights and on what the changes are. So we'll take some questions. If anyone has got any, we've got some questions which have been sent to us in prior, and there's some questions which are coming through on the Q&A. So if anyone got any other questions, please feel free to put it on Q&A or on the chat box. So, Steve, I'll start with a couple of questions we've received in advance. One of the questions was, is there any flexibility around the 20-hour rule which has been introduced now, that you have to look at the average of working less than 20 hours or more than 20 hours?
Yes, there is flexibility around that. If you have those periods which it's tested in, so it's tested in February and also in June, see whether in either of those months you worked for an average of 20 hours a week. If you didn't work, if you normally work at least 20 hours a week, but you didn't in that particular month for a valid reason, such as you were on holiday or you were sick or some such, then you can satisfy the government on an alternative basis that you normally work 20 hours a week.
Okay, excellent, thank you. The another question is regarding the alternative test. As we know that JobKeeper 1.0 had a basic test and alternative test depending on the type of the business and how the business is structured, and they don't just fit straight into the vanilla options. Is the JobKeeper 2.0 still extends the availability of the alternative test to check their eligibility?
Yes, fortunately it does. So people may be familiar with that concept. You know, obviously your business, well, the starting point is you had to compare your turnover at a corresponding period 1 year before. So there's two potential obvious ways in which that might not be fair. For example, if your turnover, you're a small business and it perhaps depends a lot on you, and the corresponding period 12 months ago you were sick or you just had an unusually bad month, then there's some various alternative ways you can satisfy the fact that your turnover has gone down, or if you weren't even in business 12 months ago. So that's all been carried. Yeah, you can then look at other periods within which you were in business that are a bit closer to the date for which you're testing your turnover. So those tests are all carried forward and they apply to this JobKeeper to the next 2 periods as well.
Yeah, so I mean, there's a lot of businesses who are seasonal in nature, or a new business was started, or there's a acquisition or a merger. So there's different scenarios you look at under the alternative test. So that's going to be quite handy to continue that under the JobKeeper number 2. Now, just quickly on the sole traders. I mean, they would continue to receive in the same way as they would under JobKeeper 1 as a business participant with the revised thresholds?
Yes, there hasn't been any change to the business participants. The only thing being that now you need to work more than 20 hours a week on average, and obviously the payments go down in a staggered way. But apart from that, the conditions, being a small business person, a sole trader, are the same as they were previously.
Okay, so we got another question here. What about if someone doesn't want to commence business due to the fear of COVID-19, like a saloon or a taxi driver who have more contact with the public? Can they still apply for JobKeeper? So from what I understand from the question is that pretty much they are not resuming their business, so their turnover would be down by 100% rather than 30%. Your comments on this?
Yes, they are still eligible because firstly, that's a reasonable reaction to Corona, but your turnover actually, the reason why your turnover is down, it doesn't have to have anything to do with Corona. There could be businesses which were actually going to do okay, but something else happened that's got nothing to do with Corona. Maybe there was a natural disaster, which your business was actually, maybe you were selling hand sanitizer, so you were going to make millions out of Corona, but then there was a natural disaster which wrecked your business. Well, you're still eligible for you've still met the turnover test. It's got nothing to do with the reason, and they just look at the pure numbers.
So, I mean, if they legitimately closed the business, I mean, because you don't have to really cite the reasons for Corona. If they really closed the doors, I mean, because the business is now shut, and would the eligibility depend on whether they're going to revive the business or they will fall out of it because now the business doesn't exist anymore? So how would they, because they're not going to be any employees if their business is shut. I suppose it's more of a question of a business participant and whether that business participant will continue to claim for it if the business is actually no chance of actually opening back up.
Yeah, it's a good question, and it's a fine line there, because if you genuinely form the intention that you are not going to resurrect this business, you've told your landlord you're walking away from the lease, you've told you've actually fired all your employees, and you've started preparing a final tax return, you've gone off to look for a job or get a job, you've sort of put it out of your power to resurrect that business, then you're not eligible because you actually need to be conducting a business. Now, businesses that are on complete deep freeze, you can ask the question, well, are they actually conducting a business? But if they have the intention to resume, if they get the chance, and that they don't have to, they may not be able to, but if they're intending to, if they can, and they've still kept as much as they can within their means of the ability to allow them to come back out of deep freeze, they haven't tried to terminate their lease. And bear in mind that it's hard, the landlord isn't allowed to terminate you for at least for non-payment of rent, although landlords can terminate for other reasons, so do be careful about that. Don't just disregard all of the provisions of your lease. I'm sure no one would do that anyway deliberately, but just so they're aware what landlords can and cannot terminate you for. But quite often, even if you can't pay your rent, you'll still have a premises, and unless your employees have got a better offer somewhere else, even though they're doing nothing, they may well be still there to receive JobKeeper. So yeah, your business can be in deep freeze. It'll look like it's shut, but we've got that intention, then you've satisfied the test. Yeah,
exactly. And so you need to show some features, if you're driving a taxi, you haven't sold your taxi, or, you still got, plant and equipment available, you're paying insurances. So you need to show those characteristics of the business being still live, even though the turnover is zero.
Exactly.
Another question is for a full-time employee employed between 1 March to 30th of June 2020, from what JobKeeper fortnight onwards, a business can claim the JobKeeper subsidy from under the new updated timing changes?
Okay, so the new JobKeeper fortnights, the first one starts on the 29th of September.
Mm-hmm.
And so you're saying if you got an employee before the 1st of July, when do you start claiming for them?
But I presume that employee could be eligible even under JobKeeper number 1 because that hasn't ended. So if their employees has joined before 1 July, between March to 30th of June, and because you can still add them into your existing JobKeeper number 1, and then if you're still eligible under JobKeeper number 2, you will continue them. Is that correct?
That's actually one that I haven't got the answer to yet. It's a very good question. I believe the answer is yes, but I don't, anyone please rely on that. We are, as people may be aware, there are some significant documentation about JobKeeper on various Fortuna websites, and we will ensure that question is answered, within the next day. And if anyone wants to know, please email. We'll provide an answer to that.
So if someone is stuck overseas and could not return to Australia to commence or resume their business, or their business is interrupted, I mean, this will depend on whether they have staff who can run the business or not. But let's assume the business is just dependent on that particular business owner, and they can't return here. Would they be eligible? My understanding would be yes, if the business still exists. And the turnover has gone down because they could not continue the business due to these circumstances. So would that be correct?
Yes, because as mentioned, it doesn't actually matter the reason why. The reason why you can't operate your business doesn't have to be due to Corona, although in that particular case, if you're out of the country and can't get back in, that will almost certainly be because of Corona, so you're sort of doubly protected there. But it's actually irrelevant if they won't be able to run their business, and if they intend to get back when they can and resurrect it to the best of their ability, then they are eligible.
Yes. Another question we have is, we will not qualify for the JobKeeper extension as our turnover will not be 30% down. However, we may need to reduce working hours. Up until now, we had people working as per normal, but procedures are now in place that we are overstaffed. Did you say that Fair Works Act allows JobKeeper directives for businesses who have a 10% turnover reduction?
Yes, look, the changes to Fair Work are complex and extensive, and they're in a bill which was introduced into Parliament 2 days ago. So we haven't actually had time to digest that yet. But so if anyone, whoever asked that question, and anyone else would like to know, would care to send us an email, or we'll be able to keep a record of the chat that may identify who that was. As soon as we've got a summary, we will post an article on the Fortuna Advisory and the Fortuna Legal websites, and we'll email that to anyone who specifically raised that question with us. There were certainly rights under JobKeeper 1 to vary your employees' hours of work because of Corona-related reasons, but employees will have some rights in the new period, but they won't be as extensive. Sorry, employers will have some rights to reduce hours, but not to the same extent as in JobKeeper 1.
Yes, okay. I think we have another question. I suppose we can take maybe another 5 minutes or so. How do we measure actual figures for the September 2020 quarter before the quarter actually ends? If the JobKeeper 2 period starts 28 September 2020, there is still a couple more days of actual income that could appear. You have identified a very time-sensitive piece of work that accountants, tax agent, and BAS agent will be involved with. Unless the applicable legislative instrument provides otherwise, it will obviously not be possible to determine whether the decline in turnover test for actual applies in September 2020 quarter has occurred until the quarter ends. The first JobKeeper fortnight for JobKeeper 2 is Monday 28th of September to Sunday 11th of October. If the requirement to satisfy the wage condition is the JobKeeper fortnight continue, it will be necessary for a business to have determined that it has satisfied the declining turnover test between 1 October and 11 October. What trust the ATO? Okay, so that's simple. That's quite simple to answer. You have to, this fortnight starts from 28th of September, doesn't mean you have to apply on 28th of September. There would be, which I don't think ATO has announced yet, but there will be a period, it could be, first week of October, where you will be lodging your applications for your eligibility for JobKeeper number 2. So you should have enough time. It'll be a small window, but you should have enough time. And if you know you're going to be heading in that direction, you should be keeping your books up to date and regular, so that as soon as the September quarter finishes, you are in a position to determine your turnover fairly quickly within the 2 or 3 days, and then apply for JobKeeper number 2. And then the payment doesn't start because it's based on a monthly payment cycle. You won't get the payment for October month, for whatever fortnights fall under that, after 31st of October anyway. So there should be enough time to be able to do that. I think, Steve, will you agree with that?
Yes, that's a good summary.
Okay, the other question is the childcare sector able to claim JobKeeper 2? I don't think there's any difference. I know the childcare sector was excluded originally when the Prime Minister made an announcement a while ago before JobKeeper 2.
Yes, there are some quite different rules for childcare, which I actually haven't had time to go into in any sort of detail. So, if we have anyone who'd like to know, we're more than happy to find out in response to a specific query.
Okay, with the business owner works full-time somewhere else and works less than 20 hours in their business, will they be eligible under the business? Well, I presume either they have to choose to first they'll if the employer is not going to claim JobKeeper for them, then they have a choice to claim as a business participant, and then as a business participant they will have to determine whether they work under 20 hours or more than 20 hours. You can't claim in both categories anyway.
No, that comes back to the question of where you're a business participant and you also have a job, which one takes priority, and that I actually don't recall. And again, if there's a specific question on the chat, we can find out and email the answer back to the person who has asked that question, because there was you couldn't just pick, you had to do one or the other. And it's a good point. If you're a business participant working part-time, and if you're forced to take it in your business participant capacity, then you're obviously getting less than if you had the freedom to go and you were working more than 20 hours with an employer. If you've got two jobs, you've got one's less than 20 hours a week and one's more than 20 hours a week, then you're free to pick the one that obviously gives you the higher pay. But because one...
Yeah, that's true. And I think my recollection, Steve, is that if you are employed and a business participant, so you're not in two jobs, your job takes the precedence. And if your employer was not going to claim for you under the JobKeeper 1 legislation, if you are employed, that takes precedence. And if your employer is not eligible and not going to claim for you, I think there's a bit of a hard luck that you can't claim as a business participant while you are employed in another job. You might have to resign from that job to be able to claim as a business participant.
Yes.
When will the last date of enrollment for JobKeeper 2? As I previously said, I don't think ATO has announced that date on the website yet. I haven't checked in the last day or so, but I don't think that date has been put on to the ATO website at this stage. Another question, should business participants start making a note of the hours per week under JobKeeper 2? I presume that's a good idea. Steve, what are your comments?
Yes, so you don't actually need to, because it's determined on one of two periods that have already passed. It's determined on either and we need to clarify exactly how the period is calculated, but a period that's approximately February 2020 or June 2020. So there's no need to record hours going forward, unless for some reason you needed to use one of the alternative tests, and then we need to find out what that test actually is, because there's no detail on that at this point. But yeah, generally no need to record. I mean, you record hours anyway. Not if you're a business participant, of course. I suppose you probably don't record your hours. So, but there is actually no need to do that. But you do need to have some. I mean, unless I suppose because you didn't know in February or June that it was relevant for you to determine how many hours you worked, and if you roughly work the same amount of hours each week, you may want to start measuring your hours now as being the best available measure for how many hours you probably worked in February or June. That's the only reason why, but there's no hard requirement to record your hours now.
Okay, I think, yeah, sorry.
Yeah, so if you did qualify as having worked more than 20 hours on average in either February or June, you can go on a big holiday and don't do any work at all for the rest of the period and still qualify. Well, yeah, you do need to do some. You need to be actively involved in the business, but yes, you could scale your hours back and yet still remain eligible on the basis that you're a more than 20 hour per week business participant.
All right, excellent, thank you. We are running short of time now, so we would like to wrap up. And if anyone has any other questions, please feel free to send your questions to support@fortunaadvisors.com.au, and we'll try to answer as quickly we can. Also, we are continuously updating our fact sheets on our resources page on Fortuna Advisory, so please stay tuned to that, or stay tuned to our emails for any other further updates. And also stay tuned for our other further upcoming webinars or events, which we'll be announcing soon. We are still taking registrations or expressions for, of course, we are helping our clients in applying for the JobKeeper, and those who are already under JobKeeper 1, and anyone wants to seek any assistance in checking their eligibility or applying for JobKeeper number 2. We've got some packages available, so please feel free to reach out to us. Once again, thank you very much for Steve for being on the panel today to explain the JobKeeper number 2, and we thank all our attendees for this morning. And the recording of the webinar would be available to all the attendees and to the applicants as well. So we'll be sending that as soon as that's ready in the next few days. Thank you very much, and enjoy your weekend, and we'll see you soon. Thank you.
Thank you, Dinesh, and thank you all for coming along.